morning and welcome to this special edition of Citizen Extra. I am Ann Kiguta, and this morning we are recapping for you the submissions by President Uhuru Kenyatta's legal team. Very shortly we'll be playing to you what they told the court yesterday as they fought to defend his election win. And later in the program we'll be taking you live to various parliamentary group meetings that are being held today. Both the Jubilee Parliamentary Group meeting and the NASA Kamkunji are expected later in the day. We'll be giving you insights on what these PGs are strategizing about, and in particular key races for House leadership. So that and more lined up for you throughout the next 3 hours. But let's begin by taking a look at yesterday's submissions before the court. Now, President Uhuru Kenyatta defended his victory, saying it was the will of the voters who should not be punished by the Supreme Court. Through his lawyers led by Fred Gatia and Ahmed Nasser Abdullahi, President Kenyatta termed NASA's petition as science fiction based on imagination, insisting that the election met the essential thresholds of a free, fair and credible poll. Here's a recap of Kenyatta's defense yesterday.
My Lord, my learned friends for the petitioner said that we are dealing with an Article 81. My Lord, if you look at even Article 81, which actually portrays the submission I'm making, Article 81 creates what I call a hierarchy of principles. And it is not by accident, it's by design. That Article 81 starts with the electoral system shall comply with the following principles. A, freedom of citizens to exercise their political right under Article 38. That is a fortification. It solidifies my submission that this actually is all about the voter who voted on 8 August. And that is why in this hierarchy of principles we start with the freedom of citizens to exercise their political rights under Article 38. So my Lord, we must never lose sight of the fact that this petitioner, the two petitioners, when they come to this court, they are challenging that right. And my Lord, that's why I say this case is about a negative invalidation of a political right under Article 38. You must find, for you to invalidate this election, that Kenyans were not entitled to exercise their political right as they did in Article 38. In other words, that right for political right is what you are negativing. It's not a case, my Lord, of saying that President Uhuru Kenyatta was not elected. No, that's not what is before you. What is before you is you must find, for you to find that the election was not conducted, you must find that Kenyans, the 15 million who voted in August 8, were not entitled to exercise their political right under Article 38. And the honors, as I will show you later on, my Lord, the burden of proof, even the standard has to shift. Because the petitioner has to satisfy you that a person who exercises his right under Article 38 was not entitled to do. And that is the only way you can invalidate this election. So my Lord, and I say, my Lord, that we need a paradigm shift. Previously we used to see this as a gladiatorial contest between the winner and the loser. No, it's not. It's not a contest between Raila and it's not a contest between the petitioner and the third respondent. It may look nice for the public viewers that this is, you know, a gladiatorial contest between the two big players. No, my Lord, this is a right-centric dispute. It is a dispute that is centered on the political right of the individual. We need to shift, my Lord, this from a contest of political supremacy and see that really what is at the substratum of a dispute in a presidential election is a right that was exercised. So, my Lord, I pray that this court impresses a right-oriented approach, which is premised on Article 38, and not a result-oriented approach, which shows that the third respondent won this contest. And my lord, that needs a lot of caution from this court. That is an argument, my lord. I will just plead that you hold it with, as Anton Scalia famously said, that some arguments you hold it with a belt and a suspender. Because a suspender may not be enough, or a belt may not be enough, although at times it's enough. But to be sure that it holds, you use both belt and a suspender, my lord. So, my lord, as I will show you later on, that it is very important that the approach you take, my lord, is not about whether IEBC did certain omissions or not in validating these elections. And my lord, let me give you an example of, a typical Kenyan setting, a herdsman for example, from Mandera, who doesn't even speak English or Swahili. He comes to a polling station. He votes with an assistance of one of the officials. He casts his vote. He may not understand the philosophical foundation of all these things, but he understands that he is making a choice. Then he walks out of that polling station and goes back to his cows or camels. My lord, can that choice of that herdsman somewhere in Mandera be invalidated because an officer did not stamp some of the forms when he filled it? Can we invalidate such a right? Can we invalidate such a basic foundation of that right? Of an illiterate Kenyan who exercised his right, who walked out of a polling station. But because one of the agents of the candidates did not sign, we say, no, that man has not voted. My lord, that will be a travesty of justice, and that's not what this constitution is all about. My lord, let me go to the second point. What is the local place, or what is the place in our local jurisprudence of Raila Odinga versus IEBC 2013, my lord? My lord, to the credit of the court, and I have expressed many times my disagreement with this court on certain issues, especially its jurisdiction. But my lord, when it comes to our electoral law or the jurisprudence created by this court, especially starting with the Raila case, followed by Peter Munya case, Zekia Obado, Nadif Jama, and Kidero, this court has expanded the regime of electoral law like no other courts I know. You have solidified, you have settled the law, and the principles of election law in this country are so settled, so certain, so firm, that this court must be given credit for that. But my lord, in the Raila case, this court have addressed many issues, and it addressed it in a very, very proper manner, my lord. It settled the law on important subjects of the law, like the burden of proof, the standard of proof, rejected votes, and even the issue of judicial restraint. And my lord, yesterday one of my learned friends raised the issue of judicial restraint. But when I submitted on the issue of judicial restraint, it's not about the court abdicating it. Judicial restraint is not about the court abdicating or laying down its pen. No. Judicial restraint is the court following the law, exercising its jurisdiction as prescribed by the law. That's what I meant by judicial restraint, my lord. My lord, even if the court will have dismissed that application and say that we expunged from the records all the pleadings filed by the first, second, and third respondents, and you allow the petitioner to prosecute this petition in our absence, it will still be dismissed. Yes. It will still be dismissed, my lord. Because, my lord, even without any defense, there is nothing they can prove in this, my lord. It's allegation of rumors. It's allegation of political hyperbole. It says that the election was conducted so badly, and you don't give particulars. But my lord, as my learned friend yesterday is rightly captured, and I said this, my lord, when I was starting, this petition is a science fiction, my lord. It's a science fiction which will only interest directors and actors in Hollywood, because, my lord, this petition is based on the theory that results that were being transmitted by the first and second respondents were intercepted by either aliens or extraterrestrial forces, changed it in favor of the third respondent. Don't explain why it was not changed on behalf of Bida or my friend Ekuru, but for the third respondent, manipulated at a frequency of 11%, and the third respondent won, my lord, as a result of that. That is pure science fiction. It can't, it's so absurd that someone can put a chart there and say that the third respondent to win an election because a computer chip has been placed somewhere that manipulated the result that led to a result that the third respondent won the election. My lord, when my learned friends from the IEPC said, leave alone about that, from the raw data on Form 34, A and B and C are there. Look at it and show us what difficulties you have. And my lord, they had no answer to that. And my lord, when they were supplied with those Form 34s as required by the rules of this court, my learned friend, my lord, Orengo said from the bar that they were photocopies, they were not original. The best evidence the petitioner has adduced, my lord, is those evidence by his lawyers. That is the best evidence they didn't. It's not by the petitioner and his witness in the affidavits, no. The best evidence, my lord, is the one adduced by Orengo from the bench. But that itself is not enough to prove his case, because it was hearsay when he said, for example, that those Form 34s are not original, my lord. Those are hearsays. That's not what a lawyer should say. So, my lord, I have 20 more minutes. I will give to my learned friend. But, my lord, I have shown that this petition is not a petition that is grounded in law. It is grounded on other grievances, my lord. It's not law. It's not a course of action. The figures and the numbers, my lord, are clear. And, my lord, for you to invalidate that presidential election, you have to show the bottom line, that the 14 million Kenyans who elected everybody else, and there is no quarrel about all the MPs, the MCS, the senators, the women representative. Nobody is unhappy about that. You have to show that those 14 people should not have voted, and they should not have voted in the manner they have voted, my lord. My lord, it's not the result one should be annoyed with, because in every contest there are winners and losers. No. You must have a bona fide, concrete course of action for you to be aggrieved. The result is a natural consequence of Article 34(2). My lord, unless you have any questions, that's the end of my submissions. I am most grateful, my lord Chief Justice.
If I could elaborate a little, my lord Chief Justice, we are in agreement that the polling stations in Kenya are 40,883. And even in the video by the late gentleman from IEBC, he refers to 40,800. We are in agreement. And the figure of 40,883 includes the 11,000. So it is not that this is a different segment from other polling stations. They are the same. And that is why this repeated complaint becomes impossible to understand. Because since all these are polling stations with Form 34A, if there is a legitimate grievance, why not go to the primary document, look at the raw data in the original form, not even in a transmitted form, but original form, and go through all these 34As, do a national tally, and come up with a result. Okay, I would write the note and read it. My lords, I go to the next point, which is ungazetted polling stations. The less I say about this, the better I believe. There was only one polling station that came into being pursuant to a judgment by the High Court, and the votes from voting did take place, and the votes were included. And again, since it's a polling station, the votes do not in any way affect the difference, the quantitative difference between the two candidates. What I mean, my lord, is this is a polling station. The polling took place due to a High Court judgment. The decree is before you. The numbers that voted in that polling station are well indicated. The voters in that area had a constitutional right set by Article 38 to participate in the election of their candidates, and that cannot be a complaint adequate on its own to invalidate a national election. My lords, I have dealt with everything at a municipal law level, because one is dealing with transmission, one is dealing with tallying, complaints about 3G network and everything. My lords, all those do not come to the level of invalidating an election conducted in accordance with the Constitution, in our humble submission. I then move to the accusations against the third respondent. The first accusation against the third respondent is that he went to Makueni, threatened and intimidated chiefs so that they could all parade Kenyans in that area to vote for him. That allegation, my lords, has been dealt with incisively and decisively in an affidavit by Dr. Kibicho, who is the Principal Secretary, Ministry of Interior, in paragraphs 22 up to 25 of his affidavit. It is noteworthy, my lords, because this is an accusation against the third respondent, that Mr. Kivisho deposed, and it's not controverted, that he, Mr. Kivisho, received intelligence reports that certain chiefs were campaigning for candidates in that area. The names of those chiefs are deposed too in the affidavit. And they were campaigning for a political party, which is NASA. And he passed that communication or that intelligence to his appointing authority. And when the third respondent was in that area, he actually told all public officers in very general terms that none should campaign for anybody, and not even himself. And when politicians take to the microphone and say, look, people, let's engage, we'll be here, this country is larger than all of us, let's not do politics, that is not a threat. It is what is expected of people in public office. The results in that area, my lord, tell the truth. One could look at the antithesis of the hypothesis that was put forward. First, petitioner garnered 301,000 votes from Makueni. 301,000 votes. Despite the so-called intimidation, my client received a paltry 27,000 votes. A small decimal of what the first petitioner received. So where is this intimidation? It is disproved by the results at the poll. It is disproved by the fact that no chief was suspended from duty. It is disproved by the fact that no chief has ever been terminated from employment. It's therefore unfair, my lords, quite unfair, for an accusation of that magnitude to be made, directed at another political player, that you intimidated persons or intimidated public officers, whereas the opposite is there. The opposite is the true position. Next one. Still with the affidavit of the Principal Secretary, the next accusation is that the third respondent went to Kisii and Nyamira talked to the IDPs in those regions and bribed them to vote for him. Those allegations, my lords, have been denied by Mr. Kivisho in his affidavit, starting from paragraph 6 all the way to paragraph 19, in which he deposed, my lords, and this cannot be denied, that this difficulty of IDPs started after the post-election violence of 2008. Successive governments have tried to resettle the victims. The current government in office, in its own budget, provided funds for the persons who had not been resettled. That budgetary provision, my lords, and this is quite important, received approval from the National Assembly. These are not funds taken away from somebody's pocket. It's the National Assembly that approved that budget. And as a continuous process, IDPs are resettled throughout the country. And the resettlement of IDPs in Kenya is within a body that is defined to in the affidavit, and which is known as the National Consultative Coordination Committee. It is that body that disburses funds to the victims. National Consultative Coordination Committee. That is the body that gets funds. The funds are approved by National Assembly and they are disbursed directly to the IDPs. My lords, there is no evidence before you that any of the beneficiaries be it in Kisii, Nyamira, or any other part of this country, because they are IDPs also, in the strongholds of the first petitioner, and they were also resettled. There is no evidence that any one of those beneficiaries was influenced by what he or she received as a resettlement from National Consultative Coordination Committee. Not a single iota of evidence. My lords, the next accusation, or before I deal with that, I leave that, there is indeed a direct authority that for any aspect to do with bribery or influence is got to be established that the inducement acted on the mind of the voter. Inducement acted on the mind of the voter and made the voter alter his decision. There can't be an inducement, so to speak, in generic terms or in general. It's got to be an inducement that is specific and induces the voter to alter his mind. We shall make this judgment available to this honorable court before we rise. No, I understand we have already submitted. Sorry? This case is a high, let me get it. It's Andrew Elam against Muhammad Rahman from the High Court of Justice, Queen's Bench Division. Muhammad Rahman, R-R-A-H-M-A-N. Inducement must act on the mind of the voter and must be operative at the material time. Next allegation against the third respondent relates to Cabinet Secretary Mucheru, who is in charge of ICT in government. I start off by making this submission that that allegation is not in the petition. It only came to our notice yesterday in an affidavit that was served yesterday and which we begged time to respond to as the petitioner was presenting their case. What is this? My lords, Mr. C.S. Mucheru was never served with that affidavit, and within the limited period that we had, we were able to prepare, file and serve an affidavit by Mr. Shishil, court stamped 28th August 2017. It is not alleged, my lords, that Mr. Mucheru was campaigning for any party. What is alleged is that he was interviewed and he said he is entitled. Is that correct? Yes, he said he is entitled to campaign. So the allegation is based on an answer to a question. And surely an offense cannot be made, or the answer cannot be the charge sheet of an accusation of such magnitude. Mr. Mucheru indicated his view about political neutrality, and citing Leadership and Integrity Act, he indicated that as a CS, he is entitled to participate in the affairs of government, including making such campaigns or advancing government policy as necessary. So, my lords, in my submission, that complaint falls flat on his feet because it is ill-founded.
And you've been listening to President Uhuru Kenyatta's rejoinder to the submissions that were initially made by the NASA brigade in court. Now, still yesterday, NASA made its final submission insisting that President Uhuru Kenyatta was illegally declared the winner of the 2017 general election. NASA's legal team, led by James Orengo, dismissed the defense of IEBC and that of Uhuru Kenyatta, arguing that although constituent results are final, IEBC Chair Wafula Chebukati failed to verify their authenticity. Here are the final submissions from yesterday.
My Lord, allow me to say with great respect that between the 8 lawyers representing the first and third respondents, they have treated not only this court, but the petitioner and the Kenyan voter with contempt. My Lord, first, the essential question that was demonstrated and must be asked were Form 34As generated, scanned and transmitted electronically and manually to the National Tallying Center, as the law requires. In their written response, paragraph 20D and 24A, they say they did. All of them. In their address to you, they admit they did not transmit at least 11,000 of those forms. But then they do not stop there, my lords. They tell you that whether those forms and images were transmitted or not is irrelevant, because the announcement was based on Form 34Bs. By so doing, they admit to have breached the law. By so doing, they endeavor to run away from the results transmitted electronically. My Lord, they then tell you, and it comes to the question therefore, that if it was manual, it was not based on the electronic transmission, were all the Form 34As transmitted to the National Tallying Center by the time of the declaration? To that then the answer no. But they add, however, all of them were eventually transmitted after the declaration of the final result. And to that then it invites the necessary legal question that if at least 11,000 Form 34As were not at the National Tallying Center, on what basis did the chairman declare the results? And then the chairman says, my lord, it was on the basis of Form 34B as received from the Constituency Tallying Center. And then they add, my lord, contrary to the law, seeking refuge in the minor care decision, that there is no obligation on the chairman to confirm that the results shown on 34B reflect the results on Form 34A. My lord, that is contrary to the minor care decision. The care decision says the result as pronounced at the polling station is final, which means, my lord, what the chairman must look at is Form 34A and then check without varying that the entries match with 34B. Then he can proceed to declare. He did not do that in this case by their own admission. But they say it does not matter because they eventually arrived anyway. My lord, it begs the legal and legitimate question, what was the hurry? The law allows the chairman 7 days. He hurried to announce on the 3rd day, 2.5 days. What was the hurry? In the end, my lord, the results are neither based on an electronic transmission, nor are they based on a manual delivery of Form 34As or Bs. It's even worse, my lord. The chairman has the audacity to tell my lords, in the response, that he saw all the 290 Form 34Bs. Then here he comes to admit that he did not tally the ones for Nyando. That is grave. That is very grave. My lord, the IBC tells you, the question is posed to them, that the law requires that the results be transmitted immediately as they come in, randomly. As we demonstrated, my lords, the results that were transmitted and displayed did not come randomly and certainly did not indicate the respective polling stations. The third respondent has endeavored to demonstrate to you the polling stations that transmitted the initial results. How the third respondent got that information is up to them. But it is not information from the public portal, and that is not disputed. But more importantly, the law requires that that information, that result must be verified and accurate. It must reflect what is in 34A. It is clear, and it was demonstrated, my lords, that the results in this case do not reflect that. What does the IBC tell you? IBC first, in their papers, they call that is a mere statistic. It is irrelevant. In court, my learned friend Mr. Nyamodi says that is mere data. When pressed by this court, it says it is a figure that was formerly called provisional results. My lords did ask them, so what are they? They could not answer. My lord, these are supposed to be results by law, transmitted electronically, and you cannot transmit inaccuracies and run away from it. But more interestingly, and sometimes this happens when you have many councils, to the very basic question, were all the 34As transmitted eventually to the National Tallying Center? My learned friend Mr. Nyamodi says yes. Issa Mansour comes later and says no. There is no requirement for delivering Form 34As. Hence the question of returns is irrelevant. My lord, this is the same IBC addressing you on such an important matter. This IBC, my lord, wants you to believe that the chairman has no role in verifying what he declares. That because the Minor K decision said the results are final, that the chairman must robotically pick them and pronounce without verifying. I submit, my lords, that that cannot be the position. But more interestingly, my lord, and I have 2 minutes to go for my own time, they transmitted these results to the entire public. A member of an expert, given those very results, analyzed them and presented them to you. Not the IEBC, not the third respondent have disputed the entries that were provided to you. Those entries tell a story through a regression analysis, an impossible story. What does the IEBC tell you and tell this country? That is Pythagoras' theorem. People paid by the taxpayers. Lawyers engaged who will be paid by the taxpayer. Some of whom are already public officers. That is Pythagoras' theorem. My lords, I respectfully submit that this court and the people of Kenya must be treated with a little more respect. My lords, lastly, and this is my closing on my part, the issue and the question that my lords did ask, the difference in presidential votes and all the others. And my lord, we did show that the difference runs into 577,000 votes. And my lords did ask the respondents the question, what accounts for that? The IEBC, my lord, through its lawyer, stand in this court and tell you with a straight face that the difference is because of the diaspora votes and the prisons votes. Their own documents show that the total number of diaspora votes is 4,000, their own documents. We are not even asking how many voted. The total number of registered voters in terms of the prisoners is 5,000. The exact number, my lord, is 5,528. Diaspora is 4,393. And they stand here, my lord, to tell you that those numbers, which come to less than 9,000, is why the president has 570,000 votes more. My lord, I submit that the contempt and unseriousness with which the IBC has treated this petition and this court reflects the unseriousness and the shoddiness with which they treated the presidential election process. Thank you, my lord.
Thank you. Thank you, Mr. Kennedy.
Thank you, my lord.
Yes, Mr. Norwich.
Thank you, my lord. Members of the court. My lord, may I turn first in reply to my learned friend Mr. Gatia's submission that the unique provisions of the election of the president is what we should be looking at. And he said that in that there was the provision to tally and then to declare the result. And he was referring to Article 138, Sub-Article 3, Paragraph C. But he left out one very important part of that provision. And the provision is this. After counting the votes, it's 138, 3C. After counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. So that right in there, right in the presidential election special provisions, is the necessity for the returning officer, the second respondent, to verify before he declares. And we submit that this indeed was not done. We go a step further, my lord, and we say it could not have been done. This is the important consideration that we wrote to the IBC on the 10th of August, the day of the result, and that is to be found. It has already been submitted by my learned friend, Honorable Otiende Amolo, in his submission. It is the letters are to be found in the petitioner's supporting affidavit, volume 1, volume 2. I'm sorry, volume 2. And at page 207, this is what we wrote to the IBC, saying, you informed the Kenyans and the world at large that IBC had received over 40,000 forms, 34A, and about 170 forms, 34B. We have requested IBC for all these forms for purposes of verification. Members of your secretariat have informed us that they can only avail 29,000 forms of 34A. So that is a gap of about 11,000 34As on the 10th of August. As at 11 p.m. of 10th August 2017, which is now after the result. So after the result, my lord, 11,000 34As were not with the IBC. They could not avail them to us. Kindly request the Commission to expedite. Then the IBC didn't reply immediately to this, and on the 14th of August we wrote again to the chairperson, which is on page 208, the next page, my lord, my ladies. This is a follow-up
of our letter of 10th August, until now, IBC has only furnished NASA with 29,000. So that is close to, my arithmetic isn't the best, 12,000. Forms 34A and 114. We urgently require the unsupplied 10,000 Form 34As. So even between the 10th of August and the 14th of August, those missing 11,000 34As had not been supplied to us. We wrote this letter on the 14th. They replied then on page 209. To the Deputy Presidential Agent from the CEO, Commission Secretary Mr. Chiloba. Reference is made to your letter of 14th August requesting to be supplied with the remaining forms that were not supplied earlier. The Commission is in a position to provide all the requested Form 34B immediately, so they could give 34Bs immediately. We are, however, not able to supply Form 34As at the moment, but the same shall be availed to you as soon as possible. My lords, my ladies, this is now 4 days after the result. If they do not have, those are not available. I use his words, they are not able to supply 34A at the moment. How then did he get to the result? I will come back to this aspect, but at this moment we submit, in reply to the submissions made on Article 38, that the returning officer, the second respondent, did not verify and therefore did not comply with Article 38, which is the article that the respondents themselves say it had been followed and is to be followed. And we say that this therefore could not lead to a result, and that the declaration of result was therefore in violation of Article 38 and could not give forth of a lawful result, a lawful declaration.
Thank you, my lord, and that's part of the high drama in this case, and it is from that that I want to begin the conclusion of the address on behalf of the two petitioners. My lords, we have not been short of drama in this case. It is learned counsel Ahmed Nasir who, raising the petition and pointing to your lordship that in this petition there is no cause of action, that it is nothing but fiction. In fact, it says it's science fiction. My lord, Mr. Hamid Nasir and his colleagues have taken this court through 6 hours of a response to a science fiction. And my lord, if it was not a science fiction, I do not think that my learned friend Mr. Hamid Nasir would have taken that amount of time together with his colleagues. And if you look at the cause of action, my lord, in terms of the petition and the pleadings, all the respondents have made responses to our pleadings and filed affidavits which ran into volumes. And again, I'm saying this, that if there was no case in the petition, these responses would not have been there. In fact, they should have taken the shortcut by making an application for striking out the petition. And having said that, my lord, there was also another very high drama in these proceedings, in which my learned friend Mr. Pielo Lumumba, whom I respect very much, in fact, my lord, if it was terms of antiquity, I'll have compared him to Cicero, who was a great lawyer and a great statesman. But my only problem, and I find it very difficult to respond to his submissions, is that the language of my learned friend, with respect, most of the time is a melange, if you wish to say so in French, is a mixture of legal texts together with common prose. So I would never know whether he is responding, in terms of the language in which the law is written, or whether he wants me to also to respond similarly in the kind of prose which is definitely poetic and for which I respect him. But my Lord, we have a definite question here. It is not about midwifery. It is about an election. Was there a free and fair election conducted by the first and second respondent? It's not about a baby. This is not a biological function or process. It's a legal process, and the product of which is a candidate who is declared a president. And by wanting to make that determination, you must go through not only the language of the text of the relevant legislation and the Constitution, but prove that indeed you have rendered an election in terms of the law. And which I want to point out from the case of Maina Kiai, which is a very important case in these proceedings and has been referred to many times. And I want to look at the penultimate paragraph of the case of Maina Kiai, which was Civil Appeal number 105 of 2017. And I think these conclusions are very important in trying to determine what type of responsibility we have in the conduct of these proceedings. And this is what the court said. The appellant, and that is the respondent in these proceedings, must in all its dealings be truly above suspicion and command the respect of the people of Kenya for whom it acts. This is what the judges are saying, that they must be above suspicion and command the respect of the people of Kenya. There's a question of legitimacy also in this process. So at the end of the day, as Kenyans go back to their beds in the evening, they go back fully confident that they have a fair deal. And they go further and say, much depends on it. Indeed, the present and future peace of the country. This is what the court is saying. It is not just about that particular electoral process which was under consideration, but it's the people who must have a good future and peace. And therefore, coming back to this, some of the findings in the Maina case, Maina Kiai, my Lord, they put a lot of weight on the question of the mode of transmission and determine why that mode was important. It's not like Mr. Nyamodi says here that the question of transmission is like a matatu. You can decide to take a matatu, take a bus, but the law prescribes which is the mode of transmission, which must be electronic. And the court gave a reason why this must be so. And they say this, having gone through the history, the context of what this country has gone through. And they say this in the judgment that I quote, which I read in part, and warn myself that I may be selectively reading this judgment as I must in the little time that I have. But they say this: the results announced at each polling station shall be transmitted to the constituency returning officer. Must be transmitted. And in another part of that judgment they say that it must be an electronic transmission. And they give the reasons why this must be so. From our reading of all the provisions under review, the authorities relied on, and bearing in mind the history that we have set in detail in the judgment, We are convinced that the amendments to the Act were intended to cure the mischief identified by the then former chairperson of the appellant and other stakeholders. And this ranged from change of results between one level of election polling station to the county, to the constituency, rather the constituency, the county, to the national tallying center. So it was necessary right at the primary level of election, which are the polling station, that a transmission, an electronic transmission must be made of the prescribed forms so that there could be verifiability of the final tally of the results. And my ladies, they say in another part, which will be the final part of this judgment, which I shall refer to, that pursuant to Section 45, Section 5, aforesaid of the technology regulations, were promulgated to provide for, among other things, information security, data availability, and this is why this scrutiny that we ask for is very important: data availability, accuracy, integrity, confidentiality, and retention of the voting materials for 3 years following the elections. So, my Lord, what am I saying? My Lord, what I'm saying is that the issue of transmission by electronic means or conveyance is an important function in which this court must be satisfied that what was transmitted is what is provided for under the law. And the law says it is not the text. In fact, the question of text is not provided for under the law. The law requires that it is the forms, the prescribed forms are the ones which must be scanned and must be transmitted for purposes of verification and for purposes of accuracy and credibility. My Lord, I must end up by again saying this to your lordships and my ladies, that elections have winners and losers. Even in court, depending on the nature of the proceedings, there are winners or losers. But at the end of the day, the process is so important as much as the result. So that even in judicial proceedings, people are interested in the process. And for that matter, therefore, my Lord, I invite your lordships and my ladies that the question of the process and how the electoral process as laid out in the law and in the regulations was carried out is an important responsibility and function of this court. And I want to finalize by saying that if a proper scrutiny is carried out as the court has ordered, if everything available that the court has added to be availed to this court is brought before the court, your lordships and my ladies will find out that this election was a shambolic election. And with that, I thank you, my lords and my ladies.
And those were NASA's final submissions before the Supreme Court yesterday. We're just about to take a short break, but we will be taking you live to the Senate very shortly, where our Stephen Latoy is standing by. Senators-elect this morning expected to undergo an induction training, particularly the first-timers in that legislative arm. We'll be talking to Stephen to find out what's going on, what are they being trained on, and the expectations ahead of the official opening of the Senate. And later, we'll also be taking you live to Lavington at the NASA Parliamentary Group meeting, which is expected to be presided over by Raila Odinga and his co-principals. That will be taking place in the next hour. They will be discussing the legislative agenda for members of Parliament. So it is certainly a very important day for incoming legislators in both houses as they prepare for what promises to be quite an exciting 12th Parliament. Citizen Extra takes a short break. We're back with more after this.